Hello, I'm Eric Pratt, and I want to thank you for watching. If you follow the news, the Supreme Court is often making headlines, and as you probably know, both Gun Owners of America and Gun Owners Foundation have been in the courts fighting for your rights in many legal cases over the years. Now, because of our legal work around the country, we sometimes get asked, well, how successful have these cases been, and are we making any headway in the courts to restore our rights? Well, these are great questions because I realize the frustration that gun owners must sense. You know, the lower courts have routinely ignored the Second Amendment, not to mention the Heller and McDonald decisions. And the Supreme Court only takes about 2% of lower court cases. So that means that most of the bad lower court decisions end up standing, right? Well, a lot of judges who have lifetime appointments will ignore the Constitution because they know they have lifetime immunity, and that's a problem. And that's why most of GOA's work involves killing bad legislation before it ever becomes law. After all, it's a lot easier to do that than spend hundreds of thousands of dollars in the courts to bring cases before judges who hate the Constitution and who can never be voted out for their unconstitutional rulings. That's why we spend so much time lobbying the Congress. Now, having said that, we are making strides in the courts. There have been some very significant cases that have helped further our gun rights. And so in this video, I want to lay out our top 10 victories over the past decade or so. Victories where Gun Owners of America and our foundation have played a role. In some cases, we worked directly with the chief plaintiffs. In other cases, we played a supporting role through amicus briefs. Some are famous cases that you'll recognize, some are not, although the unfamiliar ones are just as important to our gun rights. I'll give you a brief synopsis of these cases, but you can find out more about them and our contribution to them on our GOA and GOF websites. So without further ado, here are our top 10 legal victories where GOA and GOF were involved. Starting with number 10. Susan B. Anthony List versus Dryhouse. Now, you may never have heard of this case, but the decision in this suit is extremely important for pro-gun supporters because the net effect of this verdict means that anti-gun state bureaucrats now find it much harder to squelch the First Amendment speech of gun rights supporters. Had the Supreme Court ruled against us, state agencies would have been permitted to determine what's allegedly true or false in the context of election campaigns, essentially giving the government the power to silence or censor speech it does not like. Kind of sounds like George Orwell's Ministry of Truth, doesn't it? Well, thankfully, our position prevailed because otherwise it would make it extremely difficult for GOA to hold public officials accountable. So at number 10, this case was very important to our core mission of putting the heat on elected officials in order to preserve our gun rights. Coming in at number 9, Manuel versus Joliet. This involved a 2017 case where police dragged an African-American man out of his car. They beat and kicked him. They ripped apart the car, searching for anything illegal, and then lied about what they did find in the car. So we got involved in this litigation to help strengthen Americans' Fourth Amendment property interests, something that would obviously help protect Americans who are transporting firearms. Well, we were victorious at the U.S. Supreme Court, and this was huge because the decision now puts a greater burden on local governments that violate the property rights of Americans, including gun owners. And it provides a powerful disincentive for officials to conduct searches and seizures in violation of the Fourth Amendment. So this was an important decision too. At number 8, Henderson versus United States. In this case, a Border Patrol agent's pot-related conviction resulted in the government taking his firearms collection, which totaled more than $3,500. We went to bat for Agent Tony Henderson in 2015 and argued he should be able to sell his guns, which at the time were in the FBI's possession. The Supreme Court unanimously ruled in our favor, which was fantastic. That decision by the court was a victory for private property rights and helps to further put a barrier against the confiscation of firearms. Number 7 on our top 10 list is United States versus Arwady. Bob Arwady was a former FFL who was forced to fight all kinds of bogus charges that were brought by the ATF. This was truly an extreme case of ATF harassment. But thankfully, we were able to successfully assist him in 2015. Yeah, it took tens of thousands of dollars spent and hundreds of hours clocked in over a 6-year period, but we helped convince a jury to exonerate Arwady on all accounts. That means he was not guilty on his supposed straw purchase charge, and not guilty on the allegation claiming he was engaged in the business without a license. So this was definitely a victory for freedom, because had the ATF won, it would have been open season for the ATF to go after other innocent gun owners. That's why number 7 on our top 10 list was such a huge victory. Moving to number 6 on our list, there's Collins versus Virginia. Amazingly, the victory in this case from 2018 got praise from the strangest places. It was the liberal Slate.com that said the Supreme Court gave gun rights groups like Gun Owners of America a reason to rejoice when handing down its 8-1 ruling in Collins. And they summarized the ruling in this case as guaranteeing that cops will generally need a warrant to search a vehicle in your driveway, which protects gun owners who want to protect their homes and families using lethal force against intruders if necessary. Like I said, those were words penned by Slate magazine of all places, which means that the victory here was so obvious, even a bunch of anti-gunners could understand it. Very nice. Okay, at number 5, we have Johnson versus United States. The Supreme Court sided with us in preventing a mandatory minimum sentence from being applied against a gun owner merely because he had possessed a firearm. So the 8-1 victory in this 2015 case helps prevent the demonization of firearms and prevents the ability of prosecutors from bootstrapping almost any violation by a gun owner into a much longer jail term. That's certainly good news. Number 4 in our top 10, Rodriguez versus United States. GOA was the only group to submit an amicus in favor of Dennis Rodriguez, and we ended up with a fantastic result at the U.S. Supreme Court. The vote by the justices was 6-3 in our favor, and it sends a clear message to law enforcement that a traffic stop cannot be extended beyond its original purpose without reasonable suspicion that would justify detaining an individual in the first place. So this victory from 2015 adds an extra layer of defense for gun owners because the decision makes clear that the government cannot arbitrarily search one's home or car. As you can see, a good bit of our casework is related to protecting our property from unreasonable searches and seizures, because that, in turn, protects gun owners in possessing and carrying firearms. Okay, that brings us to our top 3 cases, which are very closely related. But before we get into those, I wanted to bring up 3 honorable mentions that didn't make the top 10. First of all, in Connecticut, we helped challenge a red flag gun confiscation order that was used to disarm a gun owner. Our in-state attorney handling the case was successful in getting the lower court's opinion overturned in the State Court of Appeals, and eventually the firearms were returned to the gun owner. Then there was a case where we challenged the state of Virginia. A gun owner was charged with willfully and intentionally lying on a 4473 form when buying a firearm. So we developed an argument that cleared the gun owner from going to jail. In fact, the Virginia Supreme Court used the argument that GOA had made in its amicus brief, which was an argument that the defendant's own attorney hadn't made. So kudos to the brilliant minds in our legal team. Now, for our final honorable mention, it's actually a group of cases that took place during the COVID pandemic of 2020. Governors and mayors were trying to use COVID as an excuse to shut down gun stores and ranges. So from coast to coast, GOA's legal team was working to stop this. And we won some very notable victories in North Carolina, Massachusetts, Maryland, and Virginia, among other places. But perhaps our most comical victory was in Durham, North Carolina, where the mayor had ordered gun stores closed. We sent a legal cease and desist letter, which prompted the anti-gun mayor to immediately reverse course, but not without a big whining session. The mayor took to the local media and howled about why he had to put up the white flag. Listen to what he said. Our lawyers said we couldn't win. They said we were going to have to pay the legal fees for Gun Owners of America and Grassroots North Carolina. And so that's why we made the decision to reopen gun stores, which is, awful. Gun stores are damaging. It's terrible to be forced into this position. I mean, you can just hear him fighting back the tears, right? Anyway, this was just one of the many great victories from around the country where we forced anti-gun politicians to open up gun stores and ranges in 2020. So back to our top 10. We have 3 cases left. And like I said, these last cases are very closely related and each of them builds off each other. Coming in at number 3 in our top 10 list is Wren versus D.C. We helped challenge Washington, D.C.'s stringent restrictions on concealed carry in this landmark case from 2018. And the D.C. Circuit agreed, ruling that the city's good reason requirement for concealed carry permits is unconstitutional. In this case, we argued that judges have no authority to use a balancing test approach to Second Amendment rights. In such instances, judges attempt to weigh whether officials have a compelling government interest which justifies restrictions on a constitutionally protected right. Or put more simply, judges try to determine if the law is more important in their eyes than the Constitution. But gun owners argue that the Second Amendment protects the right to keep and bear arms against all infringements, and that alone invalidates all judicial balancing tests. Incredibly, the D.C. Circuit broke with its own precedent and adopted the text and history approach that we were advocating and which the Supreme Court had mandated in earlier decisions. This is really significant because it sets up a potential conflict at the appellate level with other concealed carry cases that have been decided differently using balancing tests. And such conflicts can easily justify the U.S. Supreme Court taking up such a case in the future. At number 2, we have the McDonald versus Chicago case of 2010. In this case, the Supreme Court recognized that the Second Amendment protects a fundamental right which cannot be denied by states and localities. And in doing so, the Supreme Court used the 14th Amendment and the Second Amendment to strike down Chicago's ban on handguns. Again, gun owners were pleased to see that the court rejected judicial interest balancing in favor of a textual and historical analysis of the Second Amendment. Not only that, GOA was pleased to see that the contents of our brief especially resonated with Justice Clarence Thomas, who wrote a very powerful concurring opinion for the majority. In fact, it was the Thomas opinion that was later quoted heavily by a Wisconsin judge who specifically used Thomas's reasoning in ruling that the state ban on concealed carry was unconstitutional. So the McDonald case has already resulted in gun control laws being struck down, not only in Illinois, but in the rest of the country as well. And of course, we continue to use this case very heavily in our legal work today. Finally, that brings us to the number 1 case in our top 10 list. And if you hadn't guessed it by now, you haven't been following gun rights issues very closely in recent years. Because, of course, I'm talking about the D.C. Heller case from 2008. This was the landmark Supreme Court case on the Second Amendment. And in it, the court struck down quite a bit of gun control. I'll talk about that in a second. But our legal analysis offered a uniquely principled perspective in defending the right to keep and bear arms. After examining all the briefs in the case, the editors at USA Today argued that GOA's brief was the only one employing a no-compromise analysis based upon the shall not be infringed language in the Second Amendment. In fact, the legal theory in the GOA brief is the one which actually won out. In Heller, the court adopted a text and history test for the Second Amendment, which is exactly what the GOA brief had argued. The Second Amendment says that the right of the people to keep and bear arms shall not be infringed. Our brief points to that and points to the Second Amendment itself as providing its own standard of review. In other words, the standard for examining gun control is and should be no infringements. To that end, our brief also criticized other briefs which tried to defend the Second Amendment using a so-called reasonable standard. And we criticized any suggestion that gun control is compatible with the Second Amendment. Obviously, we're upset that the Heller decision contained the now infamous page 54, which, among other things, suggested that the creation of gun-free zones around schools is somehow compatible with the Second Amendment. But there's two things about that. First of all, that section is dicta. In other words, it's editorializing by the court. It's a statement, that indicates where the justices might go in the future. In fact, that language on page 54, we've learned since then, was put there by Justice Scalia to get Anthony Kennedy's vote, given that the final vote was a narrow 5-4 majority. So it stinks that the language is there, but dicta is in and of itself not binding on the lower court. So that's number one. Secondly, don't neglect how devastating the Heller decision was to the anti-gun left. In his minority dissent, Justice Stephen Breyer said that Heller threatens to throw into doubt the constitutionality of gun control laws throughout the United States. I mean, do you hear that? Gun controllers realize how demoralizing the Heller decision was, because the Heller court struck down the D.C. gun ban and trigger lock requirement. Gun grabbers believed this could never be done because they believed every gun control law to be constitutional. But they were wrong, and Heller showed them why they were wrong. Furthermore, the Heller court stated that the Second Amendment protects a fundamental individual right that is not connected to militia duty. And it argued that the Second Amendment protects modern firearms, not just muskets. Also in the Heller decision, the court spent over 50 pages analyzing the history behind the Second Amendment in a very favorable way to gun owners. So this was very helpful. Plus, the court recognized the fear that the despotic federal government could disarm people and that this was a central purpose of the amendment. By the way, we were very happy to see the Heller court address this because this was something that GOA's brief had heavily discussed. So truly, the Heller decision was a seismic shift in the legal world regarding our gun rights. It's hard to overstate the benefits of the Heller decision. After all, it is the reason that many cities later repealed their total gun bans. It is the reason that judges have been emboldened to argue for modern semi-automatic firearms. For example, Justice Kavanaugh, as a judge on the D.C. Circuit Court, used the Heller decision to argue that the D.C. ban on so-called assault weapons was unconstitutional. Not only that, we believe the Heller decision is what gave constitutional carry a much-needed shot in the arm, because having the High Court rule that Americans have a fundamental right to keep and bear arms was a game changer. Think about it. In 2008, there were only 2 states that had permitless carry. But after being emboldened by the Heller court, states started enacting these laws so that now, as I'm speaking to you, over 1/3 of the country has adopted constitutional carry. Well, last but not least, the Heller decision is important because it provided the legal basis for the second landmark gun decision 2 years later, the McDonald case, which I already discussed. There's no doubt Heller has brought about a lot of good, and that is why we list the Heller case as the #1 Second Amendment legal victory. So there you have it. Those are the top 10 Second Amendment victories where Gun Owners of America and Gun Owners Foundation have been involved. Truly, it's hard to come up with a list like this and just limit it to 10, because there have been many other important cases that GOA and GOF have fought for gun owners. We fight in the trenches where some other groups just won't go. Consider our bump stock lawsuit, which was a vital case for us to bring for a number of reasons. First of all, it's important because the Second Amendment says shall not be infringed, and the bump stock ban is an infringement. But the case was also important because the ATF regulations that we challenged actually provide the legal framework for banning AR-15s and other semi-automatic firearms in the future. Anyway, I already gave you a few honorable mentions earlier, and certainly there are others as well. Now, on the negative side, though, there are some important battles that we fought where anti-gun judges just simply refused to consider the text and history behind the Second Amendment. I'm talking about, for example, our challenge to the National Firearms Act in the Kettler case of 2019, and we challenged the Hughes Amendment, the ban on machine guns post-1986 with the case Hollis versus Lynch. That was in 2015. Ultimately, these cases contested the NFA's restrictions on machine guns and suppressors, and we argue that the Second Amendment isn't about hunting, but instead that it's about preserving liberty and preventing tyranny, just like the Heller decision said. Sadly, as you know, judges aren't always guided by the Constitution and the Second Amendment despite their oaths of office, and so we didn't see victories in those cases. I should mention, though, as a side note, that the judge in the Kettler case completely dropped all prison time against Jeremy Kettler for his possession of an unregulated suppressor. So that was good news. And you can read more about that case on our website. Anyway, even though there have been losses, there have been a lot of victories as well. And Gun Owners of America and our foundation can't do any of this without your help. We greatly appreciate your giving to our legal work. Tax-deductible contributions to that work can be made at the link on the screen or in the description. But again, we are very grateful for those of you who have already contributed to help defend gun rights in the courts. So be encouraged. It's making a difference. Thanks for watching.